36 landlord tenant cases, Arbor One versus Rico McGuire. Counsel, state your opinion.
Welcome to another intense day in Judge Simpson's courtroom. 36 landlord-tenant cases stacked back to back, an entire housing complex in legal chaos. Before we dive in, understand what's happening here. The Arbor One apartments are now condemned. That means every single tenant is technically living in a property declared unsafe by the city. You can already feel the tension. People's homes are on the line, children displaced, and landlords scrambling to avoid liability. This is not just another eviction docket. This is a full-scale housing meltdown. Pay attention to how Judge Simpson immediately takes control. He knows the stakes are high and emotions are ready to boil. Who do you think will show more restraint here? The frustrated tenants or the property management trying to defend itself? Let's find out as the first voices echo across the courtroom.
All right. The record should reflect we've had an extensive in-chambers conference, and I guess coming out of that is a couple of things. First of all, my understanding is that now all of the buildings in Arbor One West have been red tagged and are in essence condemned. What that basically means is that all of those individuals need to not be there or in those particular units. So that became the first, or once that was at least said to the court, that became the first issue of trying to figure out who has not been relocated. I want to hear from the tenants. I want to hear from the city of Ypsilanti, but I think, or the city of Ypsilanti building officials, but we've got to deal with that immediate problem. There are then two individuals who, Miss Llewellyn and then Grove, who we sent questions to, and I disclosed it to counsel, basically asking, did they wish to testify before the court? The other issue becoming whether or not they had been relocated. Again, I think the second thing I just brought up is the most important thing. Ms. Grove, can you hear me?
Yes, Your Honor.
All right. You had indicated via the chat feature that you were at 3 different hotels.
This testimony sets the emotional core of the hearing. Miss Grove's voice tells the story of displacement chaos. 3 different hotels, each booked last minute because repairs kept stalling. It's a perfect storm of mismanagement and bureaucracy. These constant moves aren't just inconvenient, they destroy stability. Kids pulled from their schools, families living out of suitcases, personal belongings trapped in condemned units. Judge Simpson's tone stays measured, but you can sense frustration rising. Every delay represents a legal failure in duty of habitability. For the tenants, every temporary fix feels like punishment for someone else's negligence. Viewers, consider this. Would you remain patient if your bathroom still wasn't fixed after multiple relocations?
Yes, so 2 weeks ago, they were going to fix our bathroom, and so they moved us into a hotel for a week. And then when we were supposed to be coming home, they give us another confirmation for another hotel because they had not started when they were supposed to, which was supposed to be on that Monday. They didn't go through that whole week. They waited until I think it was Friday, perhaps, to actually start doing the work. And then so from that Friday, Saturday to the next week, we stayed in a hotel. And then last week we finally just came back because my son has to go to school. And we weren't able to go from that part of Canton or that part of Ypsi directly to his school.
Okay.
And then they said, oh, and I'm missing a step before. I'm so sorry. There was a 4th hotel booked for last week for them to fix what they did wrong.
You can feel the fatigue in Grove's explanation. Apologies layered over exhaustion. This is more than testimony. It's trauma management on record. She's trying to remember every timeline, every failed promise, because in housing court, details are survival. The judge listens without interrupting, a sign he's calculating accountability. Each hotel stay costs money, and if landlords delayed work intentionally, that's potential damages. This sequence exposes how poor coordination between property management and contractors translates into real human chaos. The judge will soon demand clear answers. Who approved what, and when? Here's a question for you. Should tenants receive compensation when repeated temporary moves become their normal life?
But my partner did say, can you guys like reschedule or something? Like, we really can't do this right now. So there was a fourth.
Okay, thank you, ma'am. Is it Gamble? You have also not been relocated. Is she one of ours?
Yes.
Why don't you come up to the podium, ma'am? One second before I get to you. Miss Grove, I had one other question for you.
Yes, Your Honor.
When you were talking about your kids, how many kids are you talking about that you have to try to get to school?
One that I have to get to school, and one is 3 and not there yet.
Okay, gotcha. So you have one that the issue regarding schooling.
Yes, sir.
All
But
right,
we
thank
haven't-
you.
Then we haven't been.
All right. I'm sorry, Ms. Taylor. I just wanted to make sure to get that in. Okay, well, thank you. It's just nice. You need to tell these people that because they weren't listening to me when I was talking. All right. You haven't been relocated. Has there been an offer to relocate you, ma'am?
Yes, Lynette offered to relocate me 2 weeks ago, and the day that she asked me, I had to think about it. Then the next day I had to work, so it just didn't cross my mind. But she asked me on a Thursday. I don't know what day I came to see Alex Henry, but the day that I see him, that's the day that she asked to relocate.
All right. All right. Let me ask you this. How many people are in your unit? Just you? Oh, and a dog. That means there's two, right? All right.
Yeah.
So would you like to be, well, you have to be, which is the real issue.
The tone shifts here. Judge Simpson cuts through hesitation. You have to be. It's not advice, it's an order grounded in law. Once a structure is condemned, tenants must vacate. There's no legal gray area left. But look at the human side. This tenant had to juggle work, relocation, and last-minute notices. She wasn't refusing out of defiance. She was overwhelmed. This is where procedural justice meets emotional exhaustion. The judge knows forcing compliance without empathy would make him look cold, yet he's bound to enforce the code. When she mentions getting a red tag, it's a vivid reminder that eviction can happen even without wrongdoing. What would you prioritize, staying close to your job or finding any safe place to sleep?
They gave me to the 15th, which was tomorrow. So had I been relocated to a hotel that she claimed that she was going to put me in, I would have came back to the red tag anyway. So I would have had to leave again regardless. Because I got the red tag on my unit door last Wednesday.
Okay, so say that to me again. I want to make sure I'm understanding.
Okay. The day that she asked me was on a Thursday. That following week, which was last week on Wednesday, I got the red tag. When she told me that she would give me a hotel, it was going to be until April 15th, which is tomorrow. So had I been in the hotel this entire time, I would have had to come back and leave again.
Okay, so let me ask you this. If the issue wasn't resolved by the 15th, what you had to come back? So nobody told you what would happen on the 15th?
No, I just assumed that the hotel would be up and I would have to come back.
Okay. All right.
Trying to bring in peace.
Pardon?
So I'm trying to bring need peace, not pain.
Gotcha. No, it's okay. Mr. Freeman?
I just didn't hear it. I got up so I could hear better.
Oh, okay. You heard the last part that she indicated that on the 15th, she believes she had to come back because there's nothing that tells her anything different than that.
I thought she said that they don't offer to relocate.
I said that, yes.
Yeah, they did, but she would have to come back on the 15th.
I'm not relocating.
She specifically said a hotel, and she wanted to know if I wanted to be in a hotel in Ypsilanti or in Ann Arbor, because I go to school at Washington Community College, and I work at University of Michigan Hospital in Ann Arbor. She wants to know where I wanted to be at as far as a hotel.
Okay, but you don't know. Okay. All right. So where do you want to be?
I want to be in another apartment. I don't want to be in a hotel.
I know. Stay right there. So here's also part of my concern. As it stands right now, these individuals being relocated to hotels, they can't go back or aren't supposed to be going back. So, I mean, what is the longer term solution for them?
Finally, the central question lands. Short-term hotel stays are just patches on a collapsing system. Judge Simpson demands accountability. What's the plan? You can hear him push past polite updates and into real-world logistics. The lawyer admits the obvious. It's not feasible to house everyone immediately. Translation: tenants are in limbo indefinitely. This is where viewers see courtroom tension shift from compassion to confrontation. The judge wants lawful compliance, not vague intentions. The legal insight here: once properties are condemned, landlords hold continuing obligations to provide safe alternative housing or terminate leases with restitution. They can't just vanish behind insurance claims. Should local housing codes be stricter to prevent this chaos before it happens?
Well, I think that for all these cases that are in front of you, that the long-term solution is for them to be placed in other certified units, either our the villas or some other certified unit. But they're not all available immediately. So we're putting people in hotels because they can't be in the buildings. So we're putting people in hotels till we can find them places. This is not, it's not feasible at this point to just say to everybody. Plus, remember, until the latest red tagging, we were working on getting their units back together and fixed up so that a lot of them could go back, because that's a big part.
Okay, so
I'll find it.
okay, no, it's okay. All right. So, Miss Fluellen, you have already moved. Is that correct? Oh, you just muted yourself.
Okay, yes, correct.
Okay, so you already have another unit.
I moved out. I'm not dealing with them at all. I moved to a whole
Say that to me
different
again.
complex. I moved to a whole different complex. Not with them.
Got it.
Miss Fluellen's statement marks a turning point. She's done. She's moved out, cutting all ties with Arbor One management. Her frustration radiates through the screen. Privacy invaded, maintenance barging in unannounced. This isn't just tenant inconvenience. It's potential violation of the Michigan Landlord-Tenant Act regarding entry notice. The court's silence here is powerful. It's the kind of silence where everyone understands the emotional weight. When someone says, "I moved to a whole different complex," that's not relocation, it's escape. For viewers, this exposes how maintenance issues can morph into safety fears. It also highlights how trust between tenant and landlord, once broken, is nearly impossible to repair. Have you ever had a landlord enter your space without permission? How would you react?
Okay.
Due
All
to
right.
black mold, so uncomfortable in my home with the maintenance people just entering my unit.
Okay. All right. The individuals that are in back, who else, who are tenants in there? Okay.
Erica Reed would also like to speak to the court about her relocation issues.
Ms. Reed? All right. Come on out. No, you can, no, I'll make you guys share the podium.
I have a question.
Oh, hold on, Miss Llewellyn. Hello, what's your name?
Okay.
Okay. And so have you been relocated?
Yes.
Where to?
572, Delaware.
Okay. All right. You said you wanted to tell me about,
Yes, Your Honor, she hasn't had no heat since day one, and her ceiling has caved in. They keep promising her a new furnace. She is the tenant that has been living in the hotel, paying out of pocket several for over 2 weeks now.
I need that file too, please. All right. And all of that's correct, ma'am?
Yes.
So the unit that you were relocated to, the ceiling fell in?
Yes, the ceiling was out when I moved in, but they repaired it. I guess the next day. Came to the unit and it was fixed, but it was full of water. The floor was full of water. The ceiling was full of water.
Hold on. That was the new unit that you moved into?
Yes. So the same issue occurred, you know. The tub was falling out of the ceiling.
Miss Reed's testimony reinforces the absurdity. She moved into a new unit only to find it flooded the next day. The same ceiling collapse, the same water damage, the same excuses. The judge's controlled tone hides obvious disbelief. Legally, this is textbook negligence. Relocating someone into another defective unit does not satisfy the duty of habitability. It compounds liability. The pattern emerging here is systemic neglect masked as progress. Every repair creates a new hazard. For the audience, this part reveals why housing litigation moves slowly. Courts chase compliance while tenants chase safety. It's an endless loop. If you were Miss Reed, would you keep trusting these landlords or sue for emotional distress and breach of warranty instead?
So where are you now? You're in a hotel.
Well, back and forth from my mom's house and the hotel. They said they were gonna bring the furnace Thursday. Never brought the furnace.
What's your name? Got that one. What's the last name? Is there a case pending, sir? There's not. What did you want to, why don't you come on up? We'll just squeeze you all in there. Can you spell your name, please?
Bradley. Last name Johniga.
Okay. And what did you want to tell the court, although I don't have a case before me regarding?
And he says, thank you. I've asked for heat. So several times the heat works. I finally got a heater after I was berated and degraded. I asked for heat. And I was told that the heat was fixed by the certified boiler operator. I was asked for the heat back. I said, no. I'm holding my ceiling. One of the leaks from the neighbors down to my tub. So it's a big hole. And there's another leak where on the left side where the toilet is actually sticking down. So it's just a matter of time to fall on my head. I expressed to them that I'm disabled. I have 2 spinal fusion surgery that I'm healing from. So when it's cold, I'm in pain. And my nerves and shit. Said, when the heat burns, I said, well, it doesn't. Please. Since January 2nd. And then February, 2 days ago, I got the red stick, which indicated that February the 2nd,
places where we can. I'm looking at it. I just want the money that I put into the place up to January 2nd. So back so I can move somewhere else. I can't with your picture.
This plea is raw and simple. I just want my money back. The tenant isn't arguing complex law. He's demanding fairness. Months of cold, unsafe conditions, medical vulnerability, and now a red tag. Under Michigan law, if a dwelling is condemned, tenants can terminate the lease and recover prepaid rent or deposits. But that requires filing motions, paperwork, hearings, bureaucracy that favors the prepared, not the desperate. Judge Simpson's pause here matters. He's weighing empathy against procedural formality. This man represents every disabled tenant caught in legal paralysis while enduring physical hardship. Viewers, what would justice look like here? Refunds, penalties, or prosecution?
Huh? What was that last thing?
My daughter always wants to visit, but it's too cold. It's not having and it smells. It doesn't smell spoiled. All right.
Hold on a moment. Is this gentleman intending to file an affirmative complaint?
We just sent him the order to take form.
Got it. Okay. Okay. I'm not gonna cram any more people up here, maybe, I don't know. That's Mr. McGuire back there, right? And then,
Your Honor, there was one more tenant who had to leave to take her final exam, Jayla Evans.
Okay.
She says she has not yet been relocated.
Jayla Evans. Is that? And Mr. Friedman, do you know anything about Miss Evans?
She was offered a hotel. April 3rd. 24 hours. Sure. Tell me what you. This. You tell me what you. Sure.
So Miss Llewellyn is taking care of herself. Miss Llewellyn, have you guys talked to her?
Yes, we have. I think we were going to help her with a motion for escrow.
Okay. Well, I'll deal with that at some other time, but she's in that process. And has anything affirmatively been filed? I guess I shouldn't put it that way because that means something different now. But in terms of a counter complaint or anything else in the Grove matter? Did they? Okay. That may need to, okay. All right. Mr. Friedman, was there anything else that you wanted to?
Oh,
Okay. I frankly thought it wouldn't have to be said, but when I listen to Ms. Reed, when I say relocation, that's into a place that at minimum complies with the Michigan health and safety codes. I mean, you can't relocate somebody to a place they can't live.
This is where Judge Simpson draws the moral and legal line. His voice carries authority. Relocation isn't a checkbox. It's a constitutional duty of safety. The Michigan housing law requires that all residences meet minimum habitability standards, and this judge refuses to let technical compliance mask negligence. When he says you can't relocate somebody to a place they can't live, that's more than frustration. It's jurisprudence in plain English. The subtext here is scathing. He's calling out landlords who treat human relocation like shuffling paperwork. His courtroom becomes the only space enforcing human decency through statute. You can sense his frustration. Why does this even need to be said? How broken is a housing system when a judge has to remind officials that livable means more than not condemned?
I mean, it just. Yes, ma'am.
All of these further relocations, that people are telling you, it's very discouraging for me to want to move into a place that they suggest. If you understand.
Yeah, no, I get you. And let me just explain to you. So for the cases that are before me, my primary objective, while having a different one when I walked in today, right? But now looking at everything, realizing that all the buildings had been rag tagged, my primary objective is we need to get the individuals out. That really is it. But then when I listen to Reed, problem is, yeah, I gotta get you out, but I gotta get you out in a place that just meets the minimal requirements for health and safety. I mean, you can't. I could get you all out if I was gonna put you in a parking lot. I mean, but that's not what we're supposed to be doing here. So, here's what the court's gonna order. And I don't, and I'm just gonna have to specify my orders a little bit more clearly. And that is that the tenants which are subject to this court's jurisdiction are to be relocated to units or places that meet Ypsilanti housing code and the state of Michigan housing code.
This order becomes the backbone of the entire case. Judge Simpson isn't negotiating anymore. He's codifying responsibility. The language "are to be relocated" transforms compassion into law. It's a command with legal teeth. Notice how he names both city and state codes, closing loopholes for anyone trying to dodge accountability. For viewers, this is the moment bureaucracy meets justice. The court is saying, you broke it, you fix it properly. It's a quiet yet monumental shift from reactive to prescriptive justice. Tenants now have something enforceable, not just sympathetic words. The legal takeaway: judicial specificity prevents administrative evasion. Ever wonder why some orders fail in practice? Because they lack the precision you're hearing right now.
Requirements. And because I've heard from them today, I'm going to indicate that I mean, do you have children that you're trying to deal with or no?
Yes, I have, 2 20s.
Okay. Okay. So there's 3 of you. Is that no? You're 4.
13, 14, 15.
Okay. So for you, I hear you, and I wanted to hear from you because now they are at least placed on some notice. I have to have a case before I can rule specifically on your case, and it's just you, right? Right. You and the dog. I'm sorry, I didn't mean to put it that way. I just that was an awful way. And I know my mom will raise me better than that. Just say just you. All right. So here's what I'm going to order. That Miss Reed is to be relocated according to the court's new order. She doesn't have to reside in that unit that they put her in. They need to find some other unit or some other place for her to reside that meets Ypsilanti and state code. Ms. Gamble, same thing. She's to relocate to a place with and looking more toward permanency of residency, but it has to comply with Michigan state code and Ypsilanti code or the jurisdiction in which the unit resides.
By expanding jurisdictional language, Judge Simpson anticipates legal maneuvering before it starts. He's blocking the defense from arguing that unit isn't under this court's city code. It's rare to see such anticipatory precision in live hearings. He's essentially sealing the legal cracks. Then he brings up children, another pivot from code to compassion. Judges often humanize orders to show they're not mechanical. This part subtly conveys the law protects families first. Notice the blend of firmness and humanity. It's a hallmark of effective courtroom leadership. This ruling won't just apply to Arbor 1, it'll echo through future relocation disputes. In your view, should all judges adopt this proactive, preventative style, or does it risk blurring neutrality?
So that probably also should be part of that. And I'm also going to order that for the individuals in the Vance matter. Did they leave already? No, it's Grove and Vance. Yes, in Vance and Grove, that they are to be relocated to a suitable residence, with keeping in mind to cause least disruption to the family. We cannot have these relocations that are lasting at these hotels, particularly for families that are lasting a period in time without them having notification of the renewal so that they can stay there. So what I'm also going to order is that individuals that are relocated to a hotel, they are to be notified not less than 3 days prior to the expiration of the stay, that they are going to be able to continue to stay at that location.
Finally, the judge addresses one of the most overlooked injustices: uncertainty. Tenants tossed between hotels without warning, children unsure where they'll sleep tomorrow. Judge Simpson mandates a 3-day notice before hotel stays expire. It sounds small, but it's massive in lived reality. That rule gives families time to plan, to breathe, to protect their dignity. From a legal lens, this ensures procedural fairness even in temporary shelter. You can feel the collective relief in the room as he says it. For a moment, law doesn't feel distant. It feels humane. These are the kinds of micro-rulings that restore faith in the judicial system. If you were in his position, would you have imposed even stricter notice requirements to force systemic reform?
The intent is you just can't put them in there and, like Ms. Campbell was saying, well, I'm out on the 15th and I got to come back. Or like the Groves where they're bouncing around and then they all of a sudden end up back at these condemned units because they can't be there. Sir, what I've given a general order. It really doesn't necessarily apply to you, but once I have a case in front of me, my intent is going to be to have this gentleman relocated immediately to a suitable location. And as to Ms. Evans, who is not here, but I've heard from council representing her, she is also to be relocated. Do you know how many are? Okay, but she is to be relocated in accord with the order. So those are specific relocations that need to take place. Yeah. To relocate, all of these individuals are to be relocated by Friday, 5 o'clock.
Your Honor, Mr. Friedman indicated
Go ahead.
that plaintiff would reimburse Ms. Reed for her out-of-pocket hotel stay. I just want to make sure that that's also.
The court now shifts into financial territory, reimbursement for out-of-pocket hotel costs. This is where tenants' personal hardship meets measurable monetary justice. Judge Simpson demands receipts, copies, proof, because sympathy doesn't translate into enforceable rulings. By ordering reimbursement, he's setting precedent. If landlords fail to provide habitable housing, tenants shouldn't bear the economic burden. It's a subtle but sharp application of restitution law. Also, his insistence on formal documentation protects the court's integrity. Emotional testimony alone won't sustain a financial order. Viewers should recognize this pattern: empathy, verification, execution. Legal justice isn't fast, it's layered. Here's a question: should displaced tenants automatically receive stipends during condemnation, or must every dollar still be proven in court?
Mr. Friedman.
discuss that.
Yes. So, ma'am, do you have your cost of staying at the hotel?
I can get it from, because I was staying at the hotel that I work at.
Okay,
Yes, and they gave me a discount for it. 99% night.
got it. Okay. So I want a copy of your out-of-pocket expenses. I need you to submit a copy to the court. I need you also to submit a copy to, are you representing her or no?
Her answer is confirmed for answering counter complaint, but I have to.
Okay. Get that bill to legal services or that bill. So the court wants a copy. They want a copy. I also would say to get one to Mr. Friedman, but what I'm going to let happen is you get that to legal services. And I'm going to order as part of the order, and if you would, Ms. Kim, prepare an order that they are to reimburse her for her out-of-pocket expenses. Okay. All right. Was there anything else? Yes, Mr. McGuire.
I just want to know if I can get access to list, my hotel room and stuff on 15.
Do you know about that, counsel?
Yes, Mr. McGuire indicated it expired on the 6th, so.
The 15th of this month, tomorrow? Okay, well, is his unit gonna be extended? I mean, what's gonna happen with him? You're in the hotel room now. All right.
This is extended trip.
All right, it will be extended.
That short line, "it will be extended," lands like a relief valve. The courtroom tension softens for a moment. The judge ensures Mr. McGuire won't face homelessness tomorrow, but notice, no one cheers. They're too drained. This shows the emotional fatigue of litigation, relief without victory. From a legal viewpoint, extensions like this are emergency measures under equitable discretion. The court can't fix the housing system overnight, but it can stop immediate harm. This is judicial triage in action, saving lives one order at a time. Yet even here, bureaucracy lurks. Extensions expire, paperwork delays payments, and the cycle resets. How would you feel living 1 week at a time under judicial mercy?
So. All right. Was there anything else from anyone?
Yes, Your Honor.
Yes, go ahead, Ms. Grove.
I apologize for intruding. I do have one question that my partner wanted me to really make sure that I ask. Because we were in the hotel for so long, obviously with 2 kids and the 2 of us, our groceries went exponentially high. Is there any kind of reimbursement for that or per diem?
Ma'am, yeah, I understand what you're saying, and I'm not going to at this point order anything regarding that, ma'am. What I will do is I'm going to, unless there's an objection from council, I am going to check, see if there are resources within the county that may be able to assist individuals in this way, but I don't know at this point. Okay, ma'am?
Judge Simpson's restraint here is crucial. When asked about reimbursing food and travel costs, he admits uncertainty rather than offering false hope. It's an ethical response often ignored in viral courtroom clips. Judges can't just promise aid. They must operate within jurisdictional funding and law. But listen closely. He does commit to exploring county resources, signaling that compassion can coexist with legal discipline. It's a masterclass in judicial honesty. Transparent, not dismissive. For viewers, this underscores how courtrooms are limited arenas of fairness, not endless fountains of relief. If you were in charge of policy, would you fund emergency stipends for displaced tenants automatically to bypass this courtroom bottleneck?
No problem. Thank you, Your Honor.
I do hear you, and I understand that. And that was something that was, while we were in back talking, was brought up regarding food costs, regarding also just trying to get kids back and forth from school and just additional travel cost and where are the resources to help folks regarding that. So it was brought up. I'm just not prepared to rule in on that at this point.
Totally understand, Your Honor.
All right.
I have,
Yes, Ms. Llewellyn, you had something else to say?
yes, it was multiple reasons why I moved out, but my main question is my lease was up yesterday. How we go about that?
I'm sorry, your lease was up?
Yesterday.
Yes, I know. Okay, I think you had mentioned that to us.
Yeah.
So what's your question to me?
Is possible I can break my lease because I don't have a lease anymore. How do I go about breaking it and the money that I put in escrow on my own?
All right, there would have to be, you put money in escrow where?
At your courthouse in November.
At the courthouse.
Before you did a court.
Okay, there'll have
Yeah,
to be a specific, okay, that would have to be specifically addressed by me if you were seeking return of that. And we did discuss that in the parameters of that. Ma'am, when you moved in, did you pay a security deposit?
I did.
Okay, and how much was that security?
I want to say $1,000. I'm not for sure.
Okay, so, what I'm gonna ask you to do, you guys have you been working with Ms. Sloan? All right, I'm gonna ask you to contact legal services. We also talked about the parameters of how all of that was going to occur.
Okay.
For people that have moved out and who would then be relinquishing any right to the unit and how we work that out. So I would
Okay.
prefer that you talk with them and then we can see where we can go from there, okay?
Okay, because the reason why I really moved out is when it rained, it floods, and my heat wasn't working, and I'm asthmatic. It's black mold.
I got you. I hear you on everything. Let's just see if we
Okay.
can try to do the separation, how we're gonna do that, okay?
Okay.
All right. You had something else? No, I'm not. I was pointing at you.
Sorry. No, I'll just walk to the.
Okay. All right. Okay, folks, that's it. And then what I'm going to do is I'm going to adjourn these matters out. I'm keeping them on a tight leash so that as these other ones come up. And so I'm going to adjourn it to April 28th. April 28th at 9 a.m. For those who want to testify to the court, I'm going to ask you to coordinate through legal services and counsel so that maybe they're staggered throughout the day so they're not here all the time. I basically set aside that time so that we can deal with all of this. That doesn't mean you can take it, but yes. All right, yes. I basically set that aside, but the way my life goes, you never know what's going to come up and what I will have to deal with. The gentleman from Ipsy, what was the day all of the buildings became red tagged? That, if you know what I mean, that was a very badly.
April 8th was the last day of the red tag buildings. The first red tag building was on the 21st.
Okay, so as of April 8th, all the buildings were red tagged. All right. Anything else, Mr. Friedman?
A separate, different, unrelated matter.
Separate matter? Okay. But yes.
I wanted the court would address the issue of the abandonment. Notices that don't have dates and are giving tenants only 24 hours to respond. They're not residing there because of the condition.
I haven't seen those.
I do have a copy. I can share with the board and council. I don't have a printed copy, but I can copy it. Even just to make sure they have a date, maybe give them 7 days to respond, so that all their things are put out.
Well, well, they shouldn't be throwing anything out of any of these units. I mean, it's almost the assumption has to be made that they've left their unit at least temporarily because of the condemnation. I think they've run, I'm not going to specifically address it, but I will say that there probably going to be some issues if they're declaring these units abandoned under these circumstances. So, yes, ma'am.
Sorry, my last name. I had a note on my door and I meant to bring it in and take a picture of it. It still says pay Arbor One instead of pay to the court. I'm going to take a picture and send it to legal services so they can put it into the court. But yeah, it's still saying pay them instead of the court.
Pay the court or pay the city of Ypsilanti. It's all right. No, I got you. It's really as simple as that. All right.
Sorry.
I don't know who's sending those. I will get to the bottom of it. I'm going to tell you, for any rental payments, even if you have a case pending before the court, you are to pay that to the court escrow or the city of Ypsilanti. If you do not have a case pending, you pay it to the city of Ypsilanti. All right. Is that it, folks? Yes, you can go. All right, that's it.
Judge Simpson closes the session with quiet authority. His final tone mixes exhaustion and resolve, a day's worth of human chaos distilled into structured justice. Legally, he's ordered relocations, reimbursements, and oversight. Emotionally, he's given people back some control. The courtroom clears, but the weight lingers. This hearing wasn't just about housing, it was about accountability in systems designed to forget the powerless. For the audience, this ending matters. Justice isn't cinematic, it's procedural, repetitive, and painfully human. The takeaway? Courts don't fix every problem. They enforce boundaries so reform can begin outside their walls. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.